All right, well, thank you so much for having me. It's a real pleasure to be here today and kind of a little change of pace from the normal conventions in the courthouse. I want to thank Jeremy for inviting me to speak today as well. So, quite happy to be here and provide a bit of a defense perspective on cyber crimes. And I've actually tricked you all, and I'm going to be talking about the charter. So get ready, it's going to be interesting. And I've actually decided to be ironic at this sort of presentation, or at this conference, and I don't have a technological aspect to my presentation, so you're stuck just listening to me. So, as Jeremy kind of alluded to, in the courts these days, and with the crimes that are being prosecuted, there's more and more of a technological element that's coming into everything. And it doesn't mean that the offenses have anything to do with technology, but it's what's surrounding them. So, for example, when we have serious cases involving, say, murder or more elaborate investigation, we'll see all sorts of cell phone data that's being used to triangulate someone's position at a certain time. So that's being brought in. And then even in very benign, what we would think would be benign things, such as if somebody's released and they have a condition of their bail, or say a condition of probation not to contact someone. I recently saw a case where someone who had such a condition looked at somebody's LinkedIn profile, and that person was sent a notification saying that you've been someone's viewed your profile. So then we're grappling with, does this constitute contact? Have they contacted this person or had communication with them? So we're evolving in how we're using the technology and how the courts are interpreting it. Now, my next very important point is that the courts are slow. We are catching up at a very slow pace with what is going on in technology. And part of the reason, and it's very evident in my field right now, that there's a lot of delays that are happening in the court system. So by the time things are getting prosecuted, and if there's a very novel issue of law and it's going up to the appeal court, it's usually taking, if not 2, then maybe 3 years for that to be fully litigated. So by that time, the technology may have well surpassed what we're talking about. So what I'd like to do is to go through and use the example of cell phones and how cell phones are being searched and what police are able to do, how the evidence is coming into court as an example of how we're evolving. And I'm going to split it into 3 main questions based on different cases. The first one being, can the police search my phone? Second one, can the police search my buddy's phone? And the third one, can the police search everybody's phone? And the question, as any good lawyer would tell you, is it depends. So we'll go through these, and the other thing I want you to keep in mind is that in terms of the investigation that's there, the ultimate question for me as a defense lawyer is not, does the evidence exist, although that's a very important part, but is it admissible? It's one thing to have it there, but the real question is, can it be admitted into evidence before a judge? And so sometimes there's rules around evidence, and other times we're looking at the charter. And that's what I want to talk about, is the ways that the charter is being used to modify the frameworks that the court has for how we're dealing with these cell phone searches. So I'm going to quickly just give you a very brief overview about how the charter works. It's going to be the fastest one ever. So we need to know that everybody has rights under the charter. Everybody here has rights under the charter. And under Section 8, you have the right to be free from unreasonable search and seizure. And so if the police are conducting a search that we think is not in compliance with an individual's charter rights, then we can challenge that evidence. There's 2 steps to that. The first step is to establish a breach. So we establish that there was some issue with how the evidence was found. And then if we can establish a breach, then we ask that that evidence be excluded pursuant to Section 24(2) of the charter. So again, it's 2 steps: establish a breach, ask that it be eliminated because it would bring the administration of justice into disrepute. That's a fancy term to say that the society as a whole wouldn't condone what happened, and the remedy for that is that it doesn't go into evidence. So in the second prong of the test, we're looking at how serious the breach is, whether the police conduct was malicious or if it was in bad faith, and then the impact of the breach on the person, and then society's interest in having the case adjudicated before the court. So let's start with our first question. Can the police search my phone? So the case that is the seminal case on this was decided by the Supreme Court in 2014. It's called Fearon. And what happened is that the police were investigating a theft of jewelry, a robbery at a jewelry store. And they quickly center on Mr. Fearon and another man. They arrest him. At this point, they don't actually have any physical evidence. They don't have jewelry. They don't have a handgun that was alleged to have been involved. During the arrest, the officer does a pat-down search of Mr. Fearon, and lo and behold, he has a cell phone. So he opens it up, he looks through it, and, I'm sure much to his defense lawyer's chagrin, there is a draft message referring to jewelry and the words, "We did it." So, like, this is the stuff that's like when you're reading this disclosure as a defense lawyer, you're like, there's actually some more colorful language in there that I'm not going to refer to. So later the police applied for and are granted a search warrant. And they don't actually find anything else, but there's some pretty strong circumstantial evidence there of like, jewelry store, we did it. Not helpful for his defense. Okay, but the question is this evidence admissible under, like, has there been a breach of the Section 8 rights? Is this evidence admissible pursuant to the Charter? So up to this point, the courts aren't really equipped to deal with a search incident to arrest that involves a piece of technology that has such a vast and significant privacy interest as a cell phone. So what we're thinking about when we do a search incident to arrest, so that means like someone's arrested, we're going to pat you down. The test is formulated to find like a bag of weed, like a gun, something like that. It's not something that you can delve into and find a whole other slew of information, and very often private information on it. So we have this whole new scope of evidence, and the courts have to figure out how to deal with it. So what the court does is that it modifies the test around search incident to arrest. So the first step is always that the arrest has to be lawful. It has to be a valid arrest. The second one is that it has to be truly incident to arrest. So you can't arrest someone and then, like, just for the purpose of searching them. There has to be a reason to search them too that's linked to either protecting the public or the police or preserving evidence or discovering it. But what changes there is that the court says that the nature and the extent of the search must be tailored to its purpose. So that means that the search of the cell phone has to be cursory for the first point. So it has to just be a very brief, so it has to look at recent messages, drafts. So it can't be like a deep dive into what's going on there. So it's a cursory search, and the police must take detailed notes of the search. So what the court is trying to do here is it's trying to balance a person's privacy rights with the investigative powers of police so that they can properly investigate these kinds of allegations. So within the scope of the Fearon case, this requires that a phone has no password on it. Because you can't compel a person to give you their password. Again, the Association of Chiefs of Police has actually asked that there be a new law that would allow police to compel a password, which in my view is a clear breach of the right against self-incrimination, but that's another story. But again, it can also involve cases where if you have a phone where a message pops up on your home screen, even if it's locked. So that would be what that would refer to. So again, the court in Fearon is taking this, the issue, well, they actually dealt with the issue of passwords, and it's explicit in the decision saying that even if a person decides not to password protect their phone, that doesn't mean that they're abandoning all privacy rights in it. And that regardless whether it's locked or unlocked, a cell phone attracts a high degree of privacy interest. So again, the courts decide in that one, if there's a search, say on the roadside, or incident to arrest, cursory search is okay, and then after that, it gets stored into evidence, and then the police have to apply for a warrant in order to look for it in more depth. And that's kind of how they're balancing that at that point. So the next case, the next question that we'll talk about is, can the police search my friend's phone? And this is a case called Maraca that was actually just recently argued at the Supreme Court, so we don't have an answer as to the questions that were raised here. What happened in this case is that Mr. Maraca and his friend are arrested for gun trafficking. and their phones are seized from their pockets. The phones are not searched incident to arrest in this case. The police apply and are granted a search warrant, and then they find texts between the two of them that discuss gun trafficking. Again, not helpful for his defense lawyer. So the trial judge found that there is no reasonable expectation of privacy in a sent text. So the texts are on the co-accused, so Mr. Winchester, who's the other fellow involved. He has texts on his phone from Mr. Maraca. And Mr. Maraca is saying, I have a privacy interest in those texts that are on his phone, and my rights have been breached, and this shouldn't be allowed into evidence. So the question there is, if I send a text to someone here, can I expect privacy in that text once it's left my device and it's on somebody else's device? And the trial judge found that there's no reasonable expectation of privacy in the sent text. It becomes a really important question because of the issue of standing, which is that a person can only be able to challenge that if they have standing and if they have a privacy interest in that. And ultimately, the judge here says no. A person can expect privacy in a text until it reaches the recipient. So you have privacy at that point. So if it's in a server, the police can't apply to that server and get it. But once the person receives the text, then your expectation of privacy in it is gone. So the message is no longer under your control, it's under control of the recipient, and they can do whatever they want with it. And so Mr. Maraca has no standing. So that's what happens at the trial. It then goes to the Court of Appeal in Ontario, who has to decide, what is the framework that we're going to use to decide whether or not someone has a privacy interest in a technological, in something like data or a technological thing. So the test as it stands is linked to almost like property, things like that. So do you have a privacy interest? We see this sometimes if someone's driving a car. If you're a passenger in someone's car and the car gets searched, do you have a privacy interest in that? So there's a bunch of factors that the court will look at that were established in a case called Edwards, and those kind of set out what the factors are in assessing privacy interest. And again, here the question is whether they can be extended to digital privacy interest. So in the traditional framework, we look at the presence of the accused at the time of the search. We look at whether they had possession or control over the property or place searched. Do they have ownership of the place? Have they used it historically? Can they regulate access to it, including the right to admit or exclude people from the place? Is there an existence of a subjective expectation of privacy? So did that person think that they had an expectation of privacy there? Did they believe it themselves? And then was that belief reasonable? So there's an objective component to it too. Was there an objective reasonableness of privacy there? And so the court looks at this and says, you know what? This framework, we don't need to modify it. It's okay. All of these factors, they make sense if we're using a digital privacy as well, and we just need to focus on a few things more than others, and we need to look at control, access, and lack of confidentiality. So ultimately, the Court of Appeal in Ontario finds that there's a lack of empirical evidence to support a conclusion that senders of text messages have a presumptively reasonable expectation from an objective standpoint that their text messages remain private in the hands of the recipient. There's a lot of legal talk in there, but basically it just means if I send a text, then I can expect to not have any privacy interest in it once it's on someone else's phone. And now this case was argued before the Supreme Court, I think maybe 2 weeks ago, not long, and it's going to help to resolve some different case law about this. So there's a case out of BC called Palucho, where they found that the Crown in that one argued that a sender never has a reasonable expectation that it'll remain private, and they said that didn't comport with social or legal or social norms. So it's interesting in this case because what we're trying to sort out is what do normal people do? What do they think? Do you think if you send something that it should be private after that? And it's interesting to me because the way that the courts are talking, at least the Ontario Court of Appeal, is different than the sort of analysis that we get in, for example, the sending of an intimate image. So that's a really big issue that's kind of coming more and more to the courts, where we have cases of people doing sexting and revenge porn and that kind of stuff. So in those cases, it's understood if somebody sends you a picture that's intimate, then they expect that that's not going to be shared. So again, what's the difference between a text message and an intimate image? And what Morocco's counsel has argued at the Supreme Court is that the information that's sent in text messages can have some of those same hallmarks of being like going to the term they use is going to your biographical core, which is a weird way of just saying that it's intimate to you kind of thing, regardless of whether it's an image or it's a text. I mean, whether or not like we did it, we stole jewelry is intimate or goes to your biographical core is like maybe up for debate, but nevertheless. So again, the court is going to be deciding on that, and it's another way that we're seeing that these social norms, along with the ways that technology is developing and our use of it is developing, are being grappled with by the courts. So it's yet to be decided, so wait and see. So the last thing that I want to talk about very briefly is my last question of, can the police search everybody's phone? And this is a developing issue of stingrays that I'm sure people here probably know way more about than I do, but nevertheless, I just want to touch on it briefly, that we have this sort of next frontier that's coming out of stingrays, or mobile device identifiers, which if any of you don't know are essentially, I probably can't explain properly, they suck up data from lots of devices. And the issue here is how they're being used and whether or not they're compliant with the charter. And so not a lot of these cases have been litigated yet. So again, this is just sort of speculative on my part, but just looking at it, I can see that there will be a lot of avenues that defense lawyers will have to challenge the admissibility of that evidence and to challenge whether or not they should be included pursuant to charter standards. So I think what this will lead to is challenging search warrants. And so we use a form called a Garofoli application, which is almost to get behind a warrant and to have the ability to cross-examine the person that wrote the warrant to see what information they had and whether that information could form the basis of the warrant. So some issues may be that there need to be reasonable grounds to generate information about a particular offense. So it can't just be that you think maybe something happened or who knows what and you get authorization. It has to be more specific than that. And we have to show that it's being used in a minimally intrusive way. And that's going to be interesting too, especially when it has such a broad application. And then we also need to make sure that the way in which the warrant is executed complies with the terms of the warrant itself. So these are some important considerations given that the implications for this may be wider than simply the target of the warrant, given that they have such a wide scope. So again, the issues around charter and the privacy of people as we grapple with technology are evolving very quickly, much more quickly than the courts can catch up with. And it will remain to see what happens in the Morocco case. But again, I think regardless of the advances, there still needs to be that delicate balance with people's privacy interests and the investigative powers of the police. So thank you very much for having me.